Appeals Division 1 is now in session.
Thank you. You may be seated. So we are here on our case number 1CACV150732, McDivvitt versus Government Employees Insurance Company. To counsel, as you know, each side's allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve some time, you're in charge of keeping track of it for yourself. The clock on the podium will reflect the total amount that you have remaining, including what you might have decided to reserve. We record these proceedings, so when you push the podium, we'd be grateful to you if you would give us your name and the name of your client for the recording. We have read the briefs, we've studied the record, and we've also discussed the case in our conference. So with that, you may proceed. Thank you.
Thank you, Your Honors. My name is Wayne Arnett, and with me at council table is my law partner and little brother, Mark Arnett, and I represent Mr. and Mrs. Jean and Patricia McDivvitt. In this case, they are the appellants. As I was reading through the briefs last night to prepare for today, the thought occurred to me, maybe it's time to retire. I've been doing this since 1975, and I remember well the days when the legal profession was different than it seems to be today. When I began to practice law, we got along with each other, and we acted in fairness at a level playing field. And I want to say we didn't have any disagreements with opposing lawyers. Those occurred sometimes. But in fairness and an effort to get the case ready for trial and to get the discovery that we need, we could go to judges who would give us fair rulings and allow us to take the discovery that's needed in the case. If a lawyer needed more time for something, we gave it to him, and we acted in that sort of professionalism. And I did that here when they wanted to take Mrs. McDivitt's deposition after discovery had been cut off. I didn't make a fuss, didn't make them file a motion with the court. I said, sure. They hadn't gotten around to it. And to be fair, they ought to hear what she has to say. And so I allowed that, even after discovery was cut off, because that's the way I was trained to do things as a lawyer. We get along, we do what's fair, we are like Shakespeare in one of his plays said, we should be as the lawyers who strive mightily by day, but at night eat and drink as friends. That's the environment that I grew up in the practice of law. Now 42 years later, things seem to have changed.
Well, counsel, what exactly was unfair? Let's cut to the chase. What was unfair that you're claiming then?
Well, I set out to find out what the methods were that were used to value my client's vehicle. And to do that, we exchanged some disclosures. I took some depositions of the people that handled the claim. But I really they didn't know how this CCC evaluation worked. Didn't know any of the formulas that were used to calculate things like the weighted average or this baseline adjustment, which no one has been able to explain. And so I noticed the deposition.
We do know that background, but getting back to Judge Bean's question, there was nothing that prevented you from seeking production of the contracts between CCC and Geico or pursuing discovery from CCC directly. So I kind of hearken back to his question. What's unfair given that you had every opportunity to do those things? Well,
here was the problem. It isn't, well, if you look at their disclosure statement, they did say that they listed a representative of CCC. They didn't list a person's name. They didn't list an address. They didn't list a phone number. It wasn't like I could just notice the deposition of a person at CCC.
But you repeatedly told the trial court that you'd had cases with CCC, you understood how CCC operated. I just don't see lying that at the doorstep of the trial court or Geico.
Well, maybe I didn't do it exactly the way it should have been done. I obviously, in retrospect, I should have done things a little differently. What I wanted to do was to first find out what Geico knew about this process. Okay, so
and that was apparent early on.
It was not apparent until I until the judge ordered them to produce somebody at a 30B6 deposition pursuant to my request, and then they sent me a letter after that telling me that. That's fine. But I wanted to know that, and I needed that under oath. And then what my plan was once I find out what Geico knows and doesn't know, and I have that under oath, and I know that, then I can find out how this was really done to demonstrate how the vehicle was actually valued. But the problem was, because of what they did in stringing me along on the 30B6 deposition for many months, telling me we're almost there, we're going to get it for you, I'm just trying to schedule our witness, those lies pushed us up against the discovery cutoff that we had all agreed to early on in the case. And so, if they had done that and produced that witness in August when I noticed the deposition, then I would have learned that, and I could have moved on to take some more discovery to try to find out who the person is at CCC who might be able to answer these questions.
I understand why you focus on those items, but you're sort of giving short shrift to their August 14th communication that told you that a CCC representative would likely be required to explain the formulas in the CCC reports, and then at a January 28th hearing, Geico's attorney states in open court that most of the categories identified in the Rule 30b-6 notice are not things that our client can answer.
Right, and all I asked the court to do was extend the discovery deadline so that I can take that discovery, so I can find out what, I can first of all get under oath what Geico doesn't know. Couldn't do that until I took the deposition. I couldn't just rely on counsel. I can't produce counsel's statement in court to demonstrate that. And all I was asking to do was, let's extend the discovery deadline. Let's put us back, when we took the deposition in March, let's put us back where we were in August, where I would have some time to do some discovery and figure out what really went on here. That was the order I intended to do it. That's the order I was kind of forced to do it because they didn't identify someone from CCC. And yes, I have been involved in one other CCC case. In that case, I was actually criticized for not using the 30B6 deposition, and the insurance company was claiming that they weren't responsible for what CCC said. I've gone afield. I'm sorry.
That's not in the record.
Did anyone from Geico ever lead you to believe that Geico would arrange for the production of a CCC witness for you?
Well, that's what I understood it. Now, what she said was in the email. She said, I'm working on this. I'm going to have to find out what CCC can testify to, or whether someone will be needed from, or what Geico can testify to, or what witness CCC might need to testify to, because 30B6 allows them to designate under 30B6 someone else with the knowledge that is needed to answer those questions. I assumed that's what they were going to do. I expected her to say, here's what we're going to need. I'll give you a CCC person. You can find out what CCC knows, and then this person I'll give you a Geico person, and then this person will answer the remaining questions about the CCC report.
You're not saying, are you, that the cases require a party in Geico's position to arrange for the production of a witness from a separate entity like we're talking about here?
I'm not aware of cases that say that. But certainly they can if they needed to answer the questions, and I think they're very legitimate questions. How in the world did you come up with this number? And so, if they had done that in August, if they had said in August, look, you're going to have to go on Google and try to find somebody from CCC to answer these questions. We're not going to supplement our disclosure. We're not going to tell you what person at CCC we're going to call. Not going to give you an address. Not going to let you set up a deposition of the CCC person. You're on your own. I guess I could have done that. But I didn't know that in August. So they strung me along until we were right before discovery cut off, and I was trying to first get that 30B6 deposition so I could discover what's really going on from CCC if I needed to, or from Geico if they knew the answers to the questions.
So, Mr. Arnett, you're telling this court that in August of 2014 you did not know that Geico didn't place you on notice that they would you would likely need a CCC representative?
Well, I don't have, I haven't memorized those emails, but I think somewhere in August or September, or one of those emails, I believe she said that was a possibility, that maybe a CCC person would need to answer some of those questions. What she didn't say was, I'm not going to produce anybody under that 30B6 deposition from CCC. You're on your own on that, Arnett. Go find somebody. Good luck to you, and guess which CCC employee might know this stuff. She didn't do. If she'd done that, sure, I could have acted right then. I could have gone to the court and said, "Look, I need some help. Make them identify the witness that they've disclosed in their disclosure statement, so I can take depositions and be ready for this." Or make them produce somebody, or give me the name of somebody that can give me the answer. And that's one of the things I hope to get in the 30B6 deposition that I did take. Who can I go to at CCC to find the answers to these questions? So, yeah, that's exactly what would have happened if they had been upfront with me and saying, "No, we're just not going to give you that. You're just going to have to guess who at CCC might be able to answer your questions. We're not going to help out." Yeah, we could have gone to the court, could have gotten relief, could have gotten the discovery we needed to get this case ready for trial.
I guess the question for us, the bottom line, is did Judge Cooper abuse her discretion when she not only denied your motion to compel, denied your 56F filing, but also declined to grant your client more time to respond to the
right, exactly.
motion?
That's the question.
And under the circumstances, what's your best argument for why the judge abused her discretion in denying leave for more time so that you could respond with what you had?
Well, and she was well aware of this whole history. We recited it in great detail to her about what I had done to try to get that discovery. And I don't know. Like I say, I'm used to judges allowing me to take discovery before we take the case to trial or hear motions for summary judgment. And this is why I was totally blindsided by the idea that I wouldn't be allowed to get the discovery that I'd requested many months before the discovery cut off, and got strung along like I did about this 30B6 witness until it was too late, apparently. And I've never had this happen to me before, where I can, attempting to make discovery, attempting to do things and push the case along, all of a sudden I'm told, no, you should have figured out that they weren't going to produce that person. They weren't going to give you a CCC. They weren't going to amend their disclosure to name a CCC person in time for you to take their deposition for trial, and that I wouldn't be given time to respond to a motion for summary judgment and get the discovery dispute resolved, at least, so that I could file an answer to a motion for summary judgment and set forth my facts, which aren't in the record because I never was able to file a response to the motion for summary judgment.
Well, perhaps Judge Cooper believed that under Rule 56F, as it was at the time, it's something else now, that a party in the position of your client should have done what they could in responding, filed such response as they could, and sought time to take more discovery to supplement their response.
You're telling me they changed Rule 56F again since all this happened?
Well, they've changed it slightly, but
this is not good news for me. I don't know what she didn't articulate that and didn't say that. Didn't say, oh, well, you should have filed what you could in response to their statement of facts and their motion for summary judgment. But the rule itself. And that's part of what this case is about here is the interpretation of that rule. I mean, the rule itself doesn't suggest that judges should, if they deny a motion for additional discovery, should just rule on the motion without a response. In fact, they suggest the rule itself, the language of the rule suggests, set a time certain for a response and let's decide these cases on their merits. I mean, and that's really what this case is about. I mean, and maybe, I don't know, maybe that's what you want judges to do, and maybe this is a game of gotcha that we're playing now in the legal profession.
Well, it seems that the judge was bothered, as I think many trial judges would be, by the failure to comply with Rule 56F. And even the rule that talks about giving a court the ability to set a date certain for a response says if the court denies a properly supported request, and Judge Cooper clearly found that your request was not properly supported.
Yeah, and I think it was properly supported. I mean, when I filed that Rule 56F, I already had in front of her a motion to compel the discovery. This isn't one of these, I just filed this to get some extra time or to delay things. She was aware from our conferences in front of her and from the motion to compel that was filed by that time that we had a serious discovery issue here that needed to get resolved.
Rule 56F goes beyond just knowing there's a discovery dispute, and the rules requirements in terms of the affidavit of counsel have been around for years as interpreted by lots of case law, so that wasn't new law. But the requisite affidavit wasn't filed, and according to Judge Cooper, which I think is supported by the record, you didn't explain how you were unable to respond to Geico's motion without specific information.
Well, I tried to explain that I needed the information about how this car was evaluated so we could determine whether it was reasonable or not. I thought with the background of the whole discovery issue that we had in front of her, both in the conference and later in the motion to compel, that was clear, that it was the CCC issues that I needed to get discovery on so that I could respond to the motion for summary judgment. Certainly there are other aspects of the motion that I guess in retrospect I could have responded to, and would love the opportunity to. I see I'm down to 4 minutes, and I intended to reserve most of my time. And
Okay, there you go. Thank you.
Good morning, Your Honors. Josh Grable on behalf of Government Employees Insurance Company, or Geico, with the firm of Lewis, Rocha, Rothgerber, Christie. I want to make something very clear from the outset. Geico did not string Mr. Arnett along in any way. Geico did not falsify any record. In fact, Judge Downey, you clearly pointed out that the email on August 14th of 2014, the one that he says Geico in some way implied we were going to get a CCC representative in front of him, says very clearly that Geico can't testify as to some of the things that he's asking about. And in fact, Geico cannot be required under Rule 30b-6 to testify beyond Geico's corporate knowledge. You cannot ask Geico to testify about something Geico doesn't know. And you can't ask Geico, or you can't require Geico to produce a witness from another company to testify about who would do something. Quite frankly, there's a really simple solution to all of this. He was told on August 14th that we probably didn't know about it. On January 28th, and I think it's important to note, from August 14th till January 28th, he didn't in any way raise this issue of wanting to take a 30b-6 with us. Counsel changed at that point in time on behalf of Geico. The case switched from another firm to ours. At no point did he respond to us and say, we need that 30b-6 witness. Did he do anything? On January 28th, we have a motion on another issue. And on that motion on another issue, which was a motion for summary judgment on one of the counts that was granted, motion for judgment on the pleadings that was granted, Mr. Arnett says, oh, and by the way, I have this 30b-6 witness, this 30b-6 notice outstanding, and I need a witness. We said, okay, Your Honor, but there are a number of things in that request that Geico lacks the corporate knowledge to testify about. Said it on the record. Couldn't have been any clearer about it. Judge said, okay, you've got a week to tell him who your witness is going to be and what issues they can and can't testify about. And we did on February 6th, in a very clear and concise letter, outline Geico can't testify about the things from CCC that you want. How are we stringing him along? Not in any way are we stringing him along. We told him we can't do it. We then go to, we have another hearing on March 6th on another issue, and Mr. Arnett says, well, I didn't really read the letter. So what the record reflects is that he didn't really read the letter. We get to March 9th. Geico has been served with interrogatory requests, and Geico, in response to those interrogatory requests, which are consistent with the specific issues that are outlined in the 30b-6, says in response to them under oath, with a verification, we can't testify about these things, we don't have corporate knowledge. Then our witness comes and testifies, says the exact same things. the idea that we were stringing him along or that the trial court abused its discretion and allowed us to string him along when the trial court was involved and had 3 separate hearings on this issue and knew exactly what was going on and made the appropriate determination that Geico disclosed all of this information to him and that Geico's lawyers did exactly what we were supposed to do, which was to testify about what we know. Now, what are his options? He says, well, I didn't know who at CCC could testify to this. Really simple. You serve a subpoena with a 30B6 notice to CCC. That's a really simple thing, and everybody understands that that's what you do. Geico can't even tell you who at CCC would have testified on this issue because we don't know. We don't know their formulas. They are akin to an expert. They're like an engineer or a doctor who Geico relies upon to do something that they have expertise in. We take their information, we use their information in adjusting claims. We're allowed to do that. And at the end of the day, when you get through all of this allegations of improper conduct and this discussion about whether the law has changed, I've been practicing for 19 years. This is exactly the way that the law is practiced, and it has been for my entire period of time, which is that if you have a question and you have issues that you need to conduct discovery on, when you have 18 months to conduct that discovery, you do the discovery. And what the
Right, but let me ask you what I think is the closest question here, and that is, assuming the denial of 56F relief was not an abuse of discretion, not giving a date certain, even a short time frame, 5 days, 10 days, to file a response based on the discovery that had been completed. Talk to us about that decision to go ahead and enter summary judgment.
Well, I think that you're asking whether at that point is there a material issue of fact on the issues that are before the court.
Not so much that, because I think based on what Judge Cooper had before her, there wasn't a material issue of fact because there had only been arguments of counsel and allegations and pleadings, not evidence that would controvert a properly filed 56 motion. I'm asking about the decision not to give plaintiffs one last chance to respond.
Well, I think if you look at what was Rule 56F, what Judge Johnson pointed out is now Rule 56D, as I think as the new changes have come in, which substantively didn't change substantially in that change. But at that time, if you look at Rule 56C, and I will grab it so I get this quickly. The rule very clearly says that you have to file on a timely basis. And if you don't file it on a timely basis and you don't seek the relief in advance of your response, you don't get any additional time.
What, does it or does you don't get any additional time automatically?
Yeah.
But didn't the rule say the court may grant
What the rule
time?
what
Well, I'll have to get it up, I guess.
yeah. So what Rule 56F sub C3 says is no request for relief will be considered and no hearing will be scheduled unless the request for relief is accompanied by a separate statement of counsel seeking the relief, certifying that after personal consultation and good faith efforts to do so, the parties shall or have been unable to I'm sorry, I'm citing to the wrong section.
Yeah, C3.
Oh, okay. So, subsection 2 says, unless otherwise ordered by the court, the filing of a request for relief and affidavit under this section does not by itself extend the date by which the party opposing summary judgment must file a memorandum and separate statement of facts as prescribed in section C of this rule. Additionally, if you look at the comments make it very clear. You can't wait until the last day, which is what happened in this case. He waited until the day that his response was due, and then he filed a 56F motion.
So if I understand your position, you're not saying the court couldn't do it, you're just saying the court didn't abuse its discretion by not choosing to do it.
Exactly, Your Honor. The judge was well within her discretion, and I think that that the trial court worked diligently to try and find information in the record that could support her coming to a different conclusion. And then she made a discretionary call. It is completely within her discretion that there was not a basis for giving additional time on the 56F.
What would argue, focusing still on the question that Judge Downey raised, which is I'm looking for reasons to support the exercise of discretion to decline to give another 5 or 10 days just to file something in response. I suppose it's the fact that the 56F filing wasn't made until the last day. It wasn't an affidavit. And so arguably it didn't comply. Is there anything else that would support the judge's discretion?
I think that the third factor, I think Your Honor's highlighted two of the factors. I think the third factor is that there was nothing in 56F or the information that was sought that A, directly addressed the issues in the motion for summary judgment, or that B, couldn't have been raised based upon the information. And I think that, and I can't recall, but one of you mentioned earlier, the idea that he could have filed a response based on the information that he had.
Yeah.
And whether he's got this information on CCC or not, in some ways is irrelevant. The question is, did Geico properly value the vehicle? And the evidence that she had in front of her was the CCC report. She had a report from another insurance company that was in fact below our number. And she had our expert report, which is unrefuted and there's not any evidence and there's been nothing disclosed that would refute our expert, who said in his report that the CCC report valuation was accurate and correct. And so even if there was the 56F had been filed on a timely basis and had complied, he still didn't lay out the things in the 56F motion that would have properly allowed or properly demonstrated that he needed additional discovery to respond to the motion. And he didn't respond to the motion with the information that he allegedly or could have theoretically had prior to that point in time. He could have done all of those things.
Did the expert also opine that it was the standard of care to rely on a report from CCC?
I'm sorry, but
I seem to recall something in the record. You said that the expert opined that the CCC report accurately or even possibly overvalued the vehicle, but did the expert not also say that it was the standard within the industry to rely on CCC reports?
I believe the expert did say that, Your Honor, and that is also consistent with what is standard in the industry. In fact, a number of departments of insurance, not Arizona's, but in other states, have concluded that CCC's valuations are a proper way to value total losses.
Had there been an expert disclosure by the plaintiffs?
No, Your Honor. Geico disclosed, again, going back to the Geico didn't hide the ball, didn't string him along. Geico disclosed our experts on a timely basis as required by the court's order on disclosures. Plaintiff did not have an expert report in response and did not rebut that report.
So the third point that we were just talking about is that even if you take the 56F filing at face value, construed as an affidavit, it wouldn't have been necessary or sufficient to, the information sought wouldn't have been necessary or sufficient to defeat the motion for summary judgment.
Exactly, Your Honor. And I think that the trial court spent a lot of time, and if you read, and I'm sure the court has reviewed the transcript, that the trial court spent a lot of time going through the record and trying to make a determination. Again, she had multiple instances in which she'd heard about this case and the discovery issues in this case. She was acting, and then she went and she read the motions, and she exercised her discretion appropriately. And she was doing what she was supposed to do, which was to monitor the case. There were 18 months of discovery in this case. And Mr. Arnett has said here and has said in other places and said in this record that he has experience with CCC. He has to know that Geico doesn't know the formulas from CCC. And we told him that. We couldn't have been clearer on that issue. We didn't hide the ball from him in any way. I also agree with the court that there really isn't an issue in any way of material fact with regard to the summary judgment motion. And there hasn't been one that's on the record, and the judge properly entered that motion. I think that the last point that I would get to, and I'm happy to answer any other questions that the court may have on the motions themselves, but the last point that I would get to is on the cross appeal, which is just wanted to make two small points on the cross appeal on the fees. First one is Geico was not only the prevailing party, but if you look at the record, Geico made a very substantial settlement offer that was rejected by plaintiffs in the process at a settlement conference. And Geico is therefore the prevailing party, and there isn't been a finding of extreme financial prejudice, but Geico's fees were cut down to about 10% of what its actual fees were. That seems to be, there wasn't really a reason for it, it just kind of happened. We think that that's excessive and that the court should look at that. But secondarily, and potentially more importantly, is when Geico submitted its fee application, one of the things that we did was we redacted attorney-client privileged information in those fee requests. So when it said conference with Geico's attorney regarding, whatever we may have been thinking about, we redacted the stuff that we were thinking about. The entry complied with the rules in Arizona as to what we're supposed to say. It told them who was involved, how much time was spent, when they spent the time, and what they did. but didn't disclose the attorney-client privilege, and the judge struck that and said that it was improper. And I think that that is clearly a mistake by the trial court in that specific issue, because we have to be able to protect our privileged information in our time entries. Otherwise, submitting fee applications will become very dangerous for attorneys, in particular in cases where appeals may occur.
Don't lawyers on occasion put in brackets to reflect that they're modifying the bill to reflect the general topic of conversation?
Well, we could have done that, Your Honor, and what we did was, when this issue was first raised, we pointed out to the trial court that A, we only redacted things that were privileged, and B, that we could submit them to the court for in-camera review, or we could give a general description like that if was wanted. And instead, the judge simply denied and struck all of the ones in which we had redacted at that point in time. But again, based on my experience and based on what happens in both federal court and what I've done in other state court instances, we've always made that offer to the court if they really want a review to see what was specifically done. But given what the state court, what the rules are pursuant to the, and I'll get the case citation for the court.
Warner?
Yeah, pursuant to the Hawk versus PC Village case, we gave all the information that we were required to in the entry. And could I have said regarding case? Sure.
Strategy.
Regarding strategy, yeah, I mean, we could have done that, but I don't think that substantively would have changed anything, and thus the idea that we have to waive privilege to submit a proper entry for attorney's fees is truly problematic.
Can I ask you about that? Because I don't really read Judge Mullen's September 18, 2015 detailed ruling going through the associated indemnity factors as hinging on what you're just arguing. I understand your argument, and she does mention it, but I can't read this minute entry and come away with the conclusion that, but for the redaction, she would have given Geico more fees.
I don't disagree per se with Your Honor. I'm just, we are pointing this out because what she seems to be saying is, I struck all the ones where you didn't have them, and if that's what she's saying, or that's what that was something that would be one of the rationales that would support what her decision was, we would want this court to make it clear that what Geico did in this case was appropriate, or if the direction is instead what Judge Johnson just suggested, which is regarding case or regarding strategy, give the guidance to lawyers so we know when we can submit them in an appropriate way. I would agree with you, Judge Downey. It doesn't look like there was a complete striking of all of those by the trial court, but at the same time, I think that it was clearly a factor that was considered. Okay. If there are no further questions, I have nothing further for the court. Thank you.
Let me correct just one thing that counsel said, I think, inadvertently. I filed the Rule 56F motion not on the last day, the next to last day, but it was, as the rule requires, it has to be done before the response is due, and that was done in this case. Counsel admits that he knew about the 30B6 deposition request. When they took over on the case, they were well aware of it, and I don't remember any communication about it in that interim after they took over. And there's no evidence, and they don't argue that they called me to say anything about it or say, oh, we've got this outstanding 30B6, let's talk about it, let's schedule it, all the things that were going on with previous counsel. When they got over, when they came on board, it was pretty clear that that they were hoping to drag this out until the discovery got cut off the end of February and keep me from taking that deposition altogether. Well, that didn't work. I was able to take the deposition and learn what Geico learned, or what they knew, but I never was able to find out about the actual process of evaluating the claim. And that to me, the discovery should have been extended so that I could get that information. And they're stringing me out, as they did, worked for them. And as a result, my client now owes them $16,000 and some change, and never got a chance to present his case in court that they had undervalued his car. The summary judgment and we haven't focused much on this, and thank you, Judge Downey, for pointing this out, but there were some facts in this case that were admitted in the answer that would prevent summary judgment on the bad faith claim. In paragraph 17 of the complaint, we allege that in a phone call on May the 7th, Geico informed Mr. McDivvitt that it would have the check reissued and dispose of the salvage if Mr. McDivvitt agreed to their number and came in and completed the paperwork. Okay? What they were saying with this was after the first check had been sent back, they said, we'll reissue that check, but only if you agree to take the number, come in and sign the paperwork, and accept our number. Now, this is clearly withholding the undisputed portion of the claim to leverage him for settlement. And that fact was admitted in the answer. This isn't just an allegation of the complaint that judges aren't supposed to accept for ruling on motions for summary judgment. This is something that doesn't need any further proof because it was admitted in the answer that it happened exactly that way. Also, in the next paragraph, paragraph 18, the next paragraph, Geico never returned the truck as they had threatened to do in that phone call. And they did not reissue the check, and they didn't pay the undisputed amount of claim for more than 6 months after the lawsuit was filed. So, if failure to pay the undisputed portion of the claim amounts to bad faith, and I've pointed out this is different than some of the cases that say it with compulsory arbitration.
Cases that say that, but did you raise that with Judge Cooper at the time?
We never argued the motion for summary judgment. I know her minute order says there was argument held.
Yeah.
Read the transcript. There was the discussion never came up.
But what about in the motion for new trial?
Yes, of course it came up then. So it is. This is a case that on the answer alone, summary judgment should not have been granted. This is as she pointed out, you've got a pretty good case without the CCC stuff, and yet summary judgment was granted, and that should be reversed.
All right, thank you.
Thank you.
Thank you to both sets of lawyers for your briefing and your argument. We'll take the matter under advisement and issue a decision in due course. Now we stand in recess to allow the next case to set up.